Welcome back. You're watching our special coverage of the Jennifer Crumbley trial. We'll bring back in our legal experts as we await for court to resume. So as we know, this morning, sort of a big turn of events with the prosecution arguing that Jennifer Crumbley on the stand yesterday broke client-attorney privilege, and that by doing that, they can enter text messages between herself and her defense attorney in the days after the shooting into evidence. So what all of this means, we've been really hashing it out this morning. But Rick, talk about your views on an attorney turning their client in, because this is what was in question. As Jennifer said, we were awaiting advice from our attorney on whether or not we should turn ourselves in.
Right, that's what she testified to. Now, in a case like this, if I were the prosecutor, and I recall that, I'm pretty sure that I have it right, but during all of this, just as a civilian watching all this, I think that the attorney in this case was on TV saying something about my client is going to turn themselves in, or had communications about that. And my position as a prosecutor would be, in a case like this, these are people who have fled. They've had weapons in the past. They have cash. Hey, if you're going to turn yourself in, you better turn yourself in before the fugitive task force comes and knocks on your door.
Like they so dramatically did, as we saw in that
footage.
But
absolutely. Because an attorney tells a prosecutor, I want to turn my client in. Now, there are cases, obviously, nonviolent cases, or cases that are, inconsequential in the larger scheme of the criminal justice system. I'm going to turn my client in. You have a good rapport with the prosecutor, and they trust each other. That's key. You have to have trust that the defense attorney is not, blowing smoke up your skirt, and that in return, the defense attorney has client control, so the client is telling the defense attorney something that they're going to actually do. But my position has always been, as a prosecutor, and a federal prosecutor, would be, this person is a fugitive, and it's an important case, and it's a potential danger to the community and to others. There's a risk of flight, danger to the community. I find them both. If they turn themselves in, prior to getting arrested, that's great. If you're able to turn them in right now, if you're downstairs and you're calling from the basement and you want to turn them in, okay, that's great too. But no, we're not going to wait for your client to reconnoiter, come in when they want to. We're not going to wait for your client to possibly gather resources to do something that might be dangerous or a further risk of flight. These people, may have fled the country. They had travel plans. They had a boatload of cash on them. So no, there was not unreasonable at all to have this task force. I understand your position, but I'm telling you what these prosecutors thought.
They couldn't have. They couldn't have thought that.
Well, they obviously did.
No,
they arrested him with a fugitive.
This was political from the start. A warrant was issued at approximately 1 or 2 p.m. that day. Ms. Smith had previously said, I've been in touch. I'm going to turn my clients in tomorrow. I'm in court. How would the prosecution know at that point that these people are a flight risk? 8, 9 hours later? I know. I have turned people in
but nobody
on
could
homicide.
Find them, and they
of course, they were a flight risk. But of course, they were a flight risk.
How were they a flight risk?
They went from a hotel.
And what was the violence that they did?
Pardon me for talking while you're interrupting.
Well, I'm not interrupting. You're interrupting me, counsel. But please proceed.
They left. They withdrew all of the money in their account.
How did they know that?
All of the money in their account.
How did the prosecution know that?
They had burner phones. They knew
there weren't burner phones. That's another word that you keep using throughout this.
The defense attorney uses the term burner phone.
She's using the wrong term, because she even said they were replacement phones, because why? The prosecution took their phones. A burner phone is, again, planting it back in the back of your head that someone's doing something wrong.
Okay.
And the prosecution didn't know they had all this money and things until after. So let's not justify what they did after. What did the prosecution know at the time? They didn't even know where they were. They didn't know they had all this money.
They knew where they knew where they weren't. They discovered their car at a motel parking lot. They went to. They were tracking them the best they could. They had tips that they weren't going to turn themselves in.
In 7 hours.
What's the difference? 7 hours turns into 70 hours.
What violent crimes did these two people commit? I get the. That's what I'm trying to understand.
That's not the standard. What
you
violent
just said that.
I said risk
if
of
they're
flight.
Violent fugitives.
I said risk of flight, danger to the. Listen to me.
What's their danger to the community?
Listen to me. Risk
All right,
of flight, danger to the community.
I hate
They
to
should
cut
have
off-
been arrested, and
I
they
hate
were.
to cut
What's
off
the
this
danger
debate,
to the
but
community?
We do have to end the show on air.
in jail.
Thank you both. Remember, you can catch the entire trial uninterrupted over on our stream with the CBS Detroit app or Pluto TV. We'll be right back.